This is Christian News TY. I'm Tony Conyers. Is there any newsworthy events? We will get them to you as soon as possible. If not, you can follow us on Christian News TY Facebook. You can follow us on YouTube, and you can follow us on our website.
All rise. Please be seated. Yes, sir.
Your Honor, before you is Ms. Amy Rose. I've already handed up the sentencing sheets and the indictments. Your Honor, indictment 22642 or 2022 GS 43642 is a true indictment for habitual traffic offenders, which she's pleading guilty to. Waiver indictment 2022 GS 431002 is a very new case of possession of a stolen vehicle. Your Honor, I originally offered probation on the HPO. Your Honor, a brief review of the warrant on that case, provided that it could be run concurrent. Your Honor, I believe that's going to be in North Carolina versus Alford. The benefit, of course, for the plea would be that it was a concurrent sentence to the habitual traffic offender. Your Honor, it just simply turns on the mens rea issue as to whether or not she knew the vehicle was stolen. But Your Honor, we let the victims know that this plea is going forward, and we are recommending a probationary sentence.
Ma'am, raise your right hand. Yeah, I can see.
Again.
That's all right, I can see that. Come step up to the mic. Step up to that mic. There you go. State your name.
Amy Rose.
You solemnly swear affirm your testimony that shall be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
And Your Honor, one thing I forgot to mention on the habitual traffic offender indictment, number 642, being around the sentencing sheet to lift to the bench warrant, that should take care of that issue as well.
We'll get to do that while I'm thinking about it.
Yes, Your Honor. And that's why I told you, because I was thinking about it. And that's why I went ahead and told you, because I was thinking about it.
Ms. Cook, have you explained the nature and elements of the charges and possible punishment to Ms. Rose?
Yes, sir, I have.
You explained her constitutional rights, including the right to a trial and the right to have the, at least the possession of stolen vehicle charge presented to the grand jury.
Yes, sir.
You believe she understands the charges?
I do.
She understands her constitutional right?
Yes, sir.
After explaining all this to her, you believe, or does she wish to plead guilty?
She does.
You agree with her decision?
I do, Your Honor. I agree with her decision to plead guilty under the HCO and under North Carolina versus Alford for the possession of the stolen vehicle.
Ms. Rose, I'm gonna ask you a few questions. How old are you?
37.
How far did you go to school?
Graduated.
High school?
Yes, sir.
Before you were incarcerated, what were you doing for a living?
I was in a taking care of my mother that she stayed for cancer.
Married?
Yes, sir.
Children?
I got 4.
Do you suffer from any physical or mental impairment or illnesses that would prevent you from understanding what's happening here today? Have you consumed any medication, drugs, or alcohol that would affect your ability to know and understand what you're doing here today?
No, sir.
By entering a guilty plea or a plea under North Carolina versus Alford, you give up important constitutional rights. I'm gonna go through those with you. Do you understand you have the right to remain silent and not be compelled to testify against yourself?
I do.
Do you understand you have the right to a jury trial with a state that prove you guilty beyond reasonable doubt?
I do.
You understand you have the right to have your lawyer cross-examine and confront witnesses and compel witnesses to testify on your behalf?
I do.
You understand that if you were to take this case to trial and you made any statements, your lawyer would challenge those statements and the trial judge would then rule on their admissibility?
I do.
You understand you have the right to have your case, or one of these cases, I believe is the possession of a stolen vehicle case, presented to the grand jury. You understand that?
I do.
And if the way the grand jury procedure works, the state would have to present your case to the grand jury. If 12 of the 18 grand jurors believe it's probable cause that you committed this offense, they would issue an indictment. If they didn't, they would issue what's called a no bill, and your case may or may not go away. If you understand, by pleading even under North Carolina versus Alford on that charge, you waive your right to have the case presented.
I do.
understand these rights I've explained, you still wish to plead guilty to the habitual offender charge and plead under pursuant to North Carolina versus Alford on the possession of stolen vehicle.
Yes, sir, I do.
And you understand what an Alford or offer plea is?
I do.
And that's what, and for sentencing purposes and for record keeping purposes, it doesn't matter. But you are basically telling us that while you're not admitting your guilt, you are, or you understand the state may have sufficient evidence to prove your guilt, and you're trying to take advantage of the state's offer in this case,
I
correct?
am guilty.
Okay. On the possession of stolen vehicle too? All right, right, and that's what you're pleading under Alfred. Okay, I'm just making sure you understood the difference. Now, you're pleading here today to habitual traffic offender as well as possession of a stolen vehicle. You understand that? You understand both of those charges carry up to 5 years?
Yes, sir.
And you understand I can run those consecutive and give you 10 years here today?
Yes, sir.
You understand there may be some other issues by pleading guilty to the habitual traffic offender. There may be some additional driver's license suspension.
Yes, sir.
And do you fully understand the nature of the charge against you and the range of possible punishment?
Yes, sir.
Satisfied with the manner in which Ms. Cook has advised and represented you in this case?
Yes, sir.
Have you had the opportunity to review the evidence against you with Ms. Cook?
Yes, sir.
Need any more time to speak, or?
Your Honor, just to clarify, we did go over the HDO. I just found out an hour ago that she had possession of a stolen vehicle. We didn't talk about it, but we do not have discovery on that.
All right. But y'all did, yeah,
I'm sorry.
Be appointed on that case.
right.
In Your Honor, this is a brand new case, all we have is a warrant out. Technically, I don't think Ms. Cook represents her on the stolen vehicle case, although certainly we talked to Ms. Cook.
I just appointed.
Okay, thank you, Your Honor.
All right. And I know that is a very new case, but y'all need any more time to talk about it? Do you believe that Ms. Cook has done everything she could or should have done for you on your behalf?
Yes, sir.
You completely satisfied with her service?
I am.
Other than the plea negotiations that we've talked about, or that the solicitor talked about, has anyone promised you anything or in any way forced you to enter your pleas here today?
Yes, sir.
I understand you have a right to appeal your guilty and your Alfred plea and my sentence within 10 days.
Yes, sir.
Now, understand the nature of the charge, the consequences of the plea. How do you wish to plead here today?
I'm guilty.
So guilty on the habitual offender, and it's my understanding under North Carolina, you'll be pleading under North Carolina versus Alfred on the possession of stolen vehicle. Is that correct?
Yes, sir.
And what are the negotiations again?
Your Honor, we're recommending a probationary sentence at Your Honor's discretion. Both of 0 to 5 year offenses.
All right, want to tell me that?
Your Honor, may it please the court, the HDO, Your Honor, that was from November 16, 2021. Your Honor, she was pulled over following a shoplifting at Walmart. I believe she was charged a magistrate court on that one. There were other people in the car. She was driving and she was habitual traffic offender status. She had been placed in habitual traffic offender status on July 1st, 2021. This was in November. Your Honor, ultimately she was put in bench warrant status on June 24th, 2022, and she was arrested on July 27th, 2022, when, and I'm just going on the arrest warrant, Your Honor, on July 26th at 31 Harry Avenue, Ms. Rhodes had in possession a 2004 white Dodge Ram that had been reported stolen from the city of Sumter. The victim actually had located the vehicle, law enforcement arrived, and the defendant was seated in the vehicle and advised following Miranda that she had vehicle keys on her to that same vehicle. Your Honor, the reason for North Carolina versus Alford, by my understanding, is not a question about possessing the vehicle, but as to whether or not she knew it was in fact stolen, which tends to be whether those cases turn on. But I extended a plea offer of probation for the habitual traffic offender status, and I believe it is appropriate to run that concurrent regardless.
Rose, do you substantially agree with the facts that the solicitor just presented? All right, I find there's a substantial factual basis for the plea that Ms. Rose's decision to plead guilty to the habitual traffic offender charge and guilty under North Carolina versus Alford on the possession of stolen vehicle charge is freely, voluntarily, and knowingly made. She understands she is giving up important constitutional rights by entering these pleas. She has had the advice of counsel from a competent attorney whom she says she is satisfied. Ms. Cook, I'll hear from you.
Your Honor, other than what we've already been over, I guess the only thing I would like to add is that she lives in Darlington, so I believe the probation will probably transfer to Darlington. And it's my understanding she did 17 days on one charge and 3 days on the other, so.
20 days.
Yes, sir. We would ask that you go along with the state's recommendation.
And Your Honor, actually, I think she probably be better 20 days on the HDO, 17 technically on stolen vehicle, or probably do 20 on either. Because the bench one was served on that habitual traffic offender, so she would be serving that time at the same time.
I'll give her 20. All right, Ms. Rose, I'm finding to be committed to State Department of Corrections for a term of 5 years, provided that upon the service of 20 days, the balance is suspended with probation for 2 years. You understand what that means? Okay. Your sentence is 5 years, but based upon the time you served, we're gonna suspend the rest of it, and you'll have probation for 2 years.
Okay.
If you don't do what you're supposed to do during those 2 years, and you violate your probation, you got those 5 years hanging over your head, and you come back before me or another judge, and they would consider revoking it. So it's in your best interest to be on your best behavior those 2 years and get this whole matter behind you.
All right.
Good luck to you.
Thank you, Your Honor.
Your Honor, if it pleases the court, this is the state of South Carolina versus Mr. Russell E. Shields. Sir, he has indictments from, or warrants from 2012. We've got drug charge, possession of meth or crack, possession of master keys, and then 8 breaking and entering an automobile, 3 of which he does not have an attorney on. He does not appear to have an attorney on 3 of the B&E autos. He does have Attorney Charles Barr on some of the other charges. These violations, like I said, happened in 2012. His case was put into failure to appear status in 2014. He evidently was located and picked up on the bench warrant and is now in jail. Mr. Barr has evidently, he tried to call Mr. Barr and let him know he's in jail.
7 times and the sergeant at the jail. Could I say something?
Yeah, 1 second.
All right.
I want to have a lawyer in place so that we can have a motion to lift a bench warrant, someone to deal with on a plea offer, discovery, the hopeful disposition towards this case, but I have no lawyer on these, on 3 of the charges. We would love to have a lawyer from the public defender's office that we can deal a little more quickly with Mr. Shields' cases. I don't really want to activate a 2014 indictment without having something in place to start disposition, hopeful disposition.
Yep. Mr. Barnes? Mr. John, anybody?
You want to appoint us, Ron?
I'm happy to appoint the Third Circuit Public Defender's Office.
Yes, sir. We'll let our office know.
You
You know, as soon as I.
need
get a
anything
motion-
formal or an order or anything?
No, they'll believe me when I say you ordered it.
Okay. I say that because in Orangeburg, I have to sign an order for every single public defender
I
appointment. So,
understand that.
Your Honor,
everybody does a little different. I just want to make sure
Yes,
you all
sir. No,
know.
we appreciate it.
I hope that Your Honor will see Mr. Shields later this week, or we'll sign up. We're looking at bench warrant, but I'm hoping we can have a resolution to the cases finally for Mr. Shields this week.
Okay. We'll try to get it open ASAP.
You make a motion to the bench warrant, so I can do it.
And Mr. Shields, you had something you wanted to tell me?
Yes, sir.
All right.
So this is what I want to say. I don't think I did anything wrong. I did exactly what.
Whoa. I don't want you to tell me about the case right now. I want you to talk to a lawyer before you start talking about the case.
Okay, could I say something besides the case?
Yes, sir.
Okay, this is what I was getting ready to say, sir. I paid for a lawyer, $4,000.
Okay,
And I only have the one case in the state of South Carolina in Sumter. And when I went to him, I asked him, would he take this case? He said, yeah. And he told me $4,000. I paid $4,000. I paid $3,000 on, to get out on bond. He called me up 2 months, we come to a preliminary hearing with that. I went home. He called me up 3 months later and said, go to the magistrate courthouse and pay $12.75. I did that. And then 2 months later, I get a bunch of paperwork in the mail, case is over with. When I went to him, I didn't go there saying, I want you to take care of half of my case, because all this is once. I said, I want you to handle this case. And he said $4,000, he would take care. And that's what I did, sir.
well, it sounds like somebody got the wires crossed somewhere along the line.
Yes, sir.
But I know Mr. Barnes and I know the lawyers in that public defender's office, and they can help you get all this stuff straight.
So there's no way I get a PR on or nothing like that?
No, not on the bench warrant, sir. We have to have a formal motion to vacate your bench warrant.
Yes,
Mr.
sir.
Barnes knows how to do that, and I'm gonna be here all week.
I'll get back up this week.
Hopefully, I can't promise you that, but I know that they're all fine lawyers, and the state's gonna work with them to try to get this thing done.
My name is Aubrey. My name is Reagan. My name is Riley.
And my name is Robert.
For the best news,
Turn down the bass.
push that button and follow